Hello, everyone. My name is Janet Walker, and I am co-chair, together with Don Sertani, of CanArbWeek 2024. We are delighted to welcome you to this, the 5th edition of Canada's annual gathering of presentations and networking that advance the practice of international and domestic arbitration in Canada. We're pleased to begin by acknowledging that we are on the lands that have long been cared for by Indigenous peoples. Takarojo has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. Today it is home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders of the Mississaugas of the Credit First Nation that this territory is the subject of a dish with one spoon wampum covenant belt covenant, an agreement to peaceably share and care for the Great Lakes region.
This year, we concentrated our presentations into 2 very full days, featuring 11 outstanding sessions today and tomorrow. Before we begin the events, though, we'd like to thank some of the individuals and groups who were instrumental in making this possible.
First, we'd like to thank the CanArbWeek 2024 Organizing Committee, comprising, in addition to Donnie and me, and our wonderful coordinator, Sarah Van Nostrand, who's worked tirelessly through the night to make all of this possible. The Honorable Barry Leon, Mike Schafler, Lisa Munro, Doug Harrison, Dina Prokic, and Artem Barsukov. Special thanks to Dina and Artem, who have just joined us this year. You will have noticed that Nate has been missed from the list. It is, of course, our wonderful treasurer, Paul Tischauer, who we've left to last. In case any of you missed it last night, we want to give him a special shout out for his tremendous leadership throughout the first 4 years of CanArbWeek. So can the organizing committee please stand? Now today, if you have any complaints or concerns, you should come to Donnie and me. Only thanks for them, please. Second, we want to thank the CanArbWeek board, comprising, in addition to Paul and me, Pierre Bienvenu, Laura Kundari, and Mike Schafler. We greatly appreciate their coast-to-coast support for CanArbWeek.
And third, we'd like to express our sincere thanks to our sponsors. It is fantastic to see such tremendous support for the development of arbitration in Canada. And our 11 premium CanArbWeek 2024 sponsors are KPMG, our dine around dinners and badge sponsor.
Kroll, our welcome reception sponsor. We hope you all enjoyed it as much as we did. Sorry.
Bennett Jones, our coffee break sponsor, the excellent barista just outside the door.
Secretariat, our breakfast sponsor.
HKA, who's today's lunch sponsor.
BLG, tomorrow's lunch sponsor.
Arbitration Place, today's afternoon reception sponsor.
Baker McKenzie, tomorrow's afternoon reception sponsor.
McCarthy Tetril for the charging stations. You'll find them back in the room over there.
Cohen Hamilton Steger, our sports event sponsor.
And TransPerfect, our Wi-Fi sponsor.
Not sure what that was.
Yeah.
Our supporting organizations, and our 24 core sponsors. Wow. And they are ADRIC Institute of Canada, the Australian Centre for International the Australian Centre, Bay Street Chambers, Blake's, Castles and Graydon, the Centre for Arbitration and Mediation of Canadian, Canada, Brazil Chamber of Commerce, the Chartered Institute of Arbitrators Canada branch, Clyde & Co.
Deloitte Canada, Dentons Canada, Ernst & Young, Faskins, Dable ADR and Dable Bowles.
Adjudicate, JSS Barristers, Lawson Lundell, Lax O'Sullivan, Mrs. Gottlieb, Learners, American Economic Consultant.
Omni Bridgeway, Osler, PricewaterhouseCoopers, Singleton Reynolds, Toronto Arbitration Chambers, and Woods.
I think these slides might be out of order. I'm not sure what all of this is. Excuse the transitions, that's me probably at 6 a.m. this morning. Anyway, we're very, very grateful for all your support. And here are our presenting organizations.
So this is probably the right opportunity to preview the 11 events that Canada's leading arbitration organizations will present today and tomorrow under this year's theme of practically speaking. The sense we had among the organizing committee and the presenting organizations was that the arbitration community had an appetite for a practical focus to this year's content, and the organizations have put together programs that are designed to be of direct relevance to you and your practice. Given the caliber of participants we have at the conference, we hope that it will be interactive and that we'll all have a chance to benefit from each other's experience.
Yes, so thank you very much. Looking ahead, we are pleased to be able to share that next year's CanArbWeek is penciled in for 8 to 10 June 2025. Mark your calendars. And in the meantime, we look forward to seeing all of you at the sessions today and tomorrow.
And we should just say, because we've got quite a tight action-packed schedule, we are going to allow everyone to benefit from the sessions that are programmed. We're going to try to keep to time as best we can. And so I guess on that note, without further ado, it's on to our first event and the ADR Institute of Canada. The floor is yours.
And as one of the committee members and board members of CanArbWeek and president of ADRIC, it gives me double pleasure to say good morning on this dreary night after the Oilers advanced to the Stanley Cup final. So good luck to our Western friends. I am delighted to introduce to you a two-part program that ADRIC is putting on this morning. Lisa and I will be regaling you all, and you will hopefully all regale with us in a Tylney-style discussion, much shorter than maybe the time would otherwise permit. But before we take the stage, we have the pleasure to listen to two of our best practitioners in the area talk about choice of law in arbitration. They don't need much introduction, but first let me welcome to the stage Bill Horton. Bill is one of Canada's leading independent arbitrators. What's the count now? Are you up to 150 yet? Plus or minus. He's written the arbitration book, literally. And one of the things I will say about Bill, he's obviously a mentor to many in this room, including myself, but Bill and Lisa and an excellent committee at ADRIC, you'll hear more about that later this year, have been working tirelessly to roll out our new arbitration rules. It is ADRIC's 50th anniversary, and our executive director, Gary Lacasse, Gary, if you can stand just for a moment, and I are extremely proud of the progress that this committee has made. We've had a sneak preview now of these rules, and they are going to be a game changer in my humble submission. So Bill, Lisa, the rest of you already are forward-looking. Thank you for all the hard work and leadership. The other speaker also needs no introduction. Geoff Hall is a senior litigator at McCarthy's, and he has literally written the book on contract law in Canada. It's referred to in many, many decisions. Geoff, I actually use it sometimes, even though he and I have found occasion to debate issues over the years. So without further ado, gentlemen, over to you.
Well, I remembered to put my hearing aids in today. So I have my own sound system. It's just very heartening to see such a wonderful audience for those of us who've been working on growing commercial arbitration in Canada. And we're going to start the conference. There are two ways I think to start a conference on. One is with a bang, and one is to ease into it. And we're going to ease into it. This is not a challenging topic particularly, but it's an important and I think interesting topic. And that is the question of choice of law. particularly as it pertains to the interpretation of a contract. In commercial arbitrations, certainly ones that I've done, there's almost always at least one point of contract interpretation. And we become very familiar as arbitrators working with sometimes different laws, but mostly with the laws of our own jurisdictions relating to that. As important as it is, it can give rise to problems, particularly when the parties haven't applied their minds to it and really thought about the implications of that for their case. So there's an example that I happened to run into a couple of years ago that was just a perfect kind of framework for this discussion, and it also raises some other interesting issues. For example, what's the minimum you need in order to have an effective arbitration agreement? So this was a case in which I was appointed to chair a tribunal by an arbitrator, English barrister appointed by the claimant, and a New York attorney appointed by the respondent. And the interesting thing about this case, apart from its subject matter, which was also quite interesting, and I will tweak the subject, the references to the subject a little bit to maintain confidentiality, was that this agreement had no choice of law, it had no seat, it had no rules, it had no institution. The entire clause consisted of, if there's any dispute, each party will appoint an arbitrator, and those arbitrators will appoint a third arbitrator, and that tribunal will decide the dispute. That was the extent of the arbitration provision. So you might say, well, gosh, how does that ever work? Well, it turns out, it does work. Somebody's going to go to court, for example, if there's a real dispute, and if there's no cooperation in getting the tribunal up and running, and that's what happened in this case. The claimant went to the English court for interim relief. The English court granted interim relief and referred the parties to arbitration, whereupon they then cooperated in forming the tribunal. Bob's your uncle, no problem there. Now, what does the tribunal do if there's no seat, no choice of language, and these are things that have to be decided? Well, again, we tend to sometimes multiply problems in our minds, but the answer is really quite simple. The jurisdiction of the tribunal comes from the parties. The parties have empowered the tribunal to decide the dispute and anything that they need to decide along the way in order to decide the dispute. And if they need to decide what law to apply, because there's a dispute about that, then the tribunal decides what law to apply. And that's what we did. So we decided the seat because there was a dispute about that. I'm not really sure we needed to, but there was a dispute about it. The claimant wanted London as a seat. Respondent wanted New York as a seat. Claimant wanted English law to be the law of the agreement. The respondent wanted New York law to be the law of the agreement. And we considered all that. We came up with some decisions. What's the frame of reference for making that decision? Well, we thought it was whatever we thought was appropriate, given that we were asked to decide the dispute. We had to decide the dispute, so we had to come up with a way to decide the dispute. And the obvious thing was just applying international principles that are sort of widely recognized, and also comparing the law of the two jurisdictions which the parties have put forward on that issue. And as it turned out, I'll leave the seat part of it aside. But as it turned out, it wasn't really all that difficult to do. There's an analysis that we had to go through, which included, let's say, English law. English law was really the law of the jurisdiction with which the contract has its closest connection. You could look at New York law, which is a center of gravity test, and there's 5 different components to it. And we're not here to really talk about how to go about making that decision, but that's another element of it, looking at those 5 criteria. Then you can look at the Rome Convention, which is now a regulation in the EU, which places a lot of emphasis on place of performance, place of characteristic performance, and so on. So we have to go through that analysis. So that's the point is we have to go through the analysis. The parties haven't themselves chosen what law they wanted to have apply. So in the end, we ended up deciding that London was the appropriate seat. Why? The thing that weighed heavily there was the fact that the parties had been referred to arbitration by the English court. And when you look at international precedents in terms of or guidance as to how you go about deciding a seat if the parties haven't, you look at UNCITRAL, you look at the law, and there's kind of a fairly consistent test about whatever is best in the circumstances. It's a very flexible test. In this case, the fact that it was referred by an English court was important to us. And we held that New York law applied. And that was because the contract was negotiated between two lawyers in New York. And the lawyers actually became a party to the agreement because they had to exchange the money and the documents that was the characteristic performance. By the way, the lawyers also served as expert witnesses on New York law at the hearing, so they were full service lawyers. and so it was a kind of an interesting exercise. And then of course it puts the tribunal in a very awkward position in a sense. I mean, a judge would be in the same awkward position because by choosing the law, to some extent, you are also putting your thumb on the scale in terms of, you kind of know which parties are relying on which principles and why there is a dispute about that. So by making that decision, you're also in some ways prejudging what you're going to do with respect to the actual interpretation of the contract. So okay, just to say that if there's no selection of law, it's a complicated process. You're adding cost, you're adding uncertainty, and you may not like the result. Having said all of that, we have with us Geoff Hall, and I'm just delighted to be here with Geoff. I think this is the first time we've presented on anything together. And Geoff is the ultimate authority, Canadian authority on all of this. So Geoff, what are your comments in terms of how important this issue is? What differences does it make to the parties in any given case as to which law is selected? And perhaps using, of course, there's hundreds of jurisdictions and so on, but using this little example perhaps to focus the conversation.
Sure, great. Well, delighted to be here. Delighted that I have a microphone. This is pretty cool. This is the closest I will truly ever get to being a rock star, so that is good. If those of you who were here a little early and at the reception, I wasn't at the reception. I sat here to get the feel of the room, and as they were testing the sound system, they were playing AC/DC, Thunderstruck, and I thought that would be excellent to get people going first thing in the morning, but they seem to have avoided that. Great example the Bill has just given of the importance of choice of law in contracts, and particularly contractual interpretation, which, as Bill says, is where many of the issues arise in commercial arbitrations. And there is a real difference, and I don't think a lot of people think very much about how the methodology, at least, differs depending on the legal system or the choice of law that governs. So I want to speak a little bit for a couple minutes, and I will be referring to my PowerPoint eventually once I figure out where the clicker is. I don't actually have it, but in any event, I want to talk a little bit about building full service. Now the next trick will be to see whether I can actually advance the thing, but that will be different. So what I want to talk about is basically three things: how choice of law matters in contractual interpretation. Then I want to compare the common law of Canada, which I know about, and New York law, which Bill has spoken about and often comes up because there are some crucial differences, also a lot of similarities, and then a few preliminary lessons from my perspective, at least, for drafting and advocacy on this choice of law issue. So first, how does choice of law matter to contractual interpretation? It certainly affects methodology. Different legal systems approach the interpretive exercise differently. And that means that you have to be alive to the legal system to know how to frame your arguments in order to be persuasive. And although I'm not an arbitrator, it would seem to me you need to be alive to the system in order to write awards that are going to have legitimacy in and acceptance in whatever system there is. And I have some personal experience in this. I have argued 2 international arbitrations involving contract issues in the US under different US law, and it is methodologically different. The arguments are posed differently, are structured differently, the awards look different than we would expect. Whether it really matters to the outcomes is a little bit less clear, and we may talk about that a little bit when we go on. So let's take a look, if I can advance this thing a little bit. There we go. Isn't that exciting? I'm going to skip over some of my slides because I don't really like PowerPoint all that much. But I want to talk a little bit about New York and common law Canada in terms of interpretive techniques. And big qualifier here, I'm not qualified in New York or any other US jurisdiction, so take what I have to say for what it's worth, which may be nothing. But if you look at New York law, in terms of its interpretive principles, what is striking from a common law perspective, a common law Canadian perspective, is that there is much that is similar, but one key thing that is very different. So I've got some comparisons on the screen of some principles that are familiar to us who practice under a common law system. So starting with the concept of interpreting the text as a whole. You have a dispute over certain words, certain phrases, but the courts are quite clear in Canada. You need to look at the agreement as a whole to put everything in context. So the Ontario Court of Appeal said some 30 years ago, the various clauses of the contract cannot be considered in isolation, but must be given an interpretation that takes the entire agreement into account. And the Ontario courts have actually expanded that to interrelated contracts entered into at the same time. Listen to the way the New York courts articulate the same thing. The entire contract must be reviewed, and particular words should be considered not as if isolated from the context, but in the light of the obligation as a whole and the intention of the parties as manifested thereby. Sounds pretty similar. What the New York judge wrote would be correct in Ontario or any other common law Canadian jurisdiction. Okay, one down. Let's take a look at another principle. Commercial principles, the use of commercial principles to determine a commercial contract, to understand from a commercial perspective what the parties were trying to do and thereby get their intention. Key part of Canadian common law, and again, I'm going to go back to some old law from the Ontario Court of Appeal, 1992. I use this quotation all the time. The agreement with which we are concerned is a negotiated commercial agreement, which should be construed in accordance with sound commercial principles and good business sense. And that's a very powerful maxim, and I've seen it in action. I have a war story I tell about a trial that I did in court a number of years ago on the commercial list with a very experienced commercial judge. I don't think he's here now, but he's retired. And it was quite striking because after a day of evidence, he stopped the evidence and asked a series of questions about the business, because it wasn't my witness, I'm pleased to say, but it managed to go through a day of evidence without him understanding what the business was. What was the product that was being sold? What was the marketing plan? All that sort of thing. And he was uncomfortable with the dispute until he understood those things. Look at what New York does. Same thing. The terms of the contract should be construed according to wrong quotation. I'm reading from my paper, not from the screen. The entire contract must be reviewed, and particular words should be considered, not as if isolated from the context, but in light of the obligation as a whole and the intention of the parties as manifested thereby. So again, it sounds very similar. Where does it get different? Right here. Factual evidence beyond the text. In Canadian common law, this is of course foundational, the factual matrix, the surrounding circumstances. Often as important as the text, sometimes even more so, shouldn't be, but sometimes it is. So the key case on this is Schafler, the agreement with which, sorry again, wrong one, decision maker must read the contract consistent with the surrounding circumstances known to the parties at the time of formation of the contract. Consideration of the surrounding circumstances recognizes that ascertaining contractual intention can be difficult because words alone do not have an immutable or absolute meaning. And that's very different in New York. New York is much more literal, much more focused on the text, the four corners. Statement from New York, and there are many of them. We could have taken a written agreement that is complete, clear, and unambiguous on its face must be enforced according to the plain meaning of its terms. Canadian concepts, plain meaning doesn't exist. There is no such thing without the context, the factual circumstance in which the language is used. In New York, you look at the contract. If you get the answer from the contract itself on its face, there's no ambiguity, that's it. You don't look at any factual evidence. It's only if there is a grammatical ambiguity on the page, words could support two or more equally plausible meanings, that you can look to factual circumstances to resolve the conflict. That's a big difference, and it makes a big difference, at least in methodology. And that's why Bill's story is a great one, because if you don't write your choice of law clauses and you leave it to the arbitrators to decide, you are leaving to the arbitrators a major methodological issue. So drafting lessons, make sure you include a governing law clause, and think about it. It's not just boilerplate. Choosing between Canadian common law jurisdictions doesn't really matter, but if you're choosing New York or Delaware, which is also quite a literalist jurisdiction, most US jurisdictions are the same way, you are dictating a different methodology of contractual interpretation. And then for the advocacy lesson, if you're presenting this before an arbitrator, think about the legal system in terms of how you advance your case. In New York or a US jurisdiction that is more literal, you pull out your grammar books and your dictionaries, and you start parsing the language. And it's quite remarkable how it can degenerate into a kind of a grade 10 grammar exercise to figure out what the agreement is worth. In Canada, common law Canada, the factual narrative is key. And we see this even in very recent jurisprudence. On Friday, the Supreme Court of Canada issued a case called Earth Co., which delved very deeply into the factual circumstances to determine the actual bargain between the parties, almost ignoring the text, with a vociferous dissent by Justice Cote, who pointed more to the text. So it's a big methodological difference, but does it matter in practice? Phil, any thoughts on that or anything else?
Well, you know, it does and it doesn't. So when this comes up, first of all, I just add to what you said, that there, you know, and there's a tension even within Canadian law between the literalists and the contextualists, and you can see the cases flowing back and forth. The high point of the textualist approach is the Iacobucci and Eli Lilly, which keeps getting quoted. You know, wait a minute. You know, if the parties have said something plainly, we don't really need to look at anything else. So there is definitely a force within Canadian jurisprudence that's trying to overcome this contextual approach. Why is that? Because a contextual approach takes you way out in left field sometimes once you get into the adversarial process and the parties are trying, what parts of the context are relevant? Do you look at drafts of the agreement? Do you look, you know, all kinds of negotiations, all those things. And as a practical matter, that really weighs on the Canadian system, I would say. And in arbitration, we have a little bit more of an ability to control that, because in litigation, a lot of that exploration of this extraneous context takes place outside the purview of the court. Whereas in arbitration, the arbitrator can make determinations that limit the contextual exploration that goes on pre-hearing. So that's to my mind, that's a definite advantage of arbitration within the Canadian system. Now, with respect to the American approach, we're not here, by the way, to be definitive about anything. We're just trying to highlight a problem here. And later on, everyone can ask whether we got this right on New York law. But when you come down to the hearing and the merits, there is the same struggle, whether it's New York law, whether it's Canadian law, between the fairness and the literal application of the words. And what I've found is that lawyers in all jurisdictions, including American lawyers, have found techniques in the United States to bring context more into it. For example, okay, but are the words plain in their meaning? Is this how the parties were using the words? You can get a lot of context out of recitals in an agreement. You can get a lot of context by looking at a little bit further afield within the four corners of the document, which maybe a Canadian lawyer wouldn't, because they're looking for context outside the document. So you're looking in different places, but you're looking in different places to get at the same thing. Are we going to hold people to a literal bargain that's not fair? Or are we going to rewrite the contract for them? And then that's the same, no matter what system you're under. I think that's universal to dispute resolution. But let's just, maybe we only have about 5 or 6 minutes left. In arbitration, unlike courts, you get to choose your arbitrator. So not only do you get to choose your law, but you get to choose the person before the tribunal that's going to apply the law. How important is that from a counsel point of view, Geoff? And do you take that into account?
Oh, absolutely, absolutely. It's one of the things I find very strange about, not strange, but different about arbitration. In the courts, check shopping is a bad thing. You're not supposed to do it. Forum shopping, bad thing. Arbitration, it's the whole game. You spend a whole bunch of time on it. Yeah, absolutely. And you look very much on this approach. You consider whether your potential nominees are on where they are on this spectrum between fairness and the text, between certainty and individualized justice. And we vet you guys. I have had discussions about people in this room, perhaps people on this dais, as to their approach to contracts. So your reputations matter, and they are talked about in the legal community, and they will affect when you are nominated and when you are not.
Yeah, absolutely. And I get calls from people from time to time asking for an opinion on something they're thinking about appointing. The number one question I get is this person likely to take a literal approach, a strict approach to the contract, or are they a fairness person? Hopefully, in most cases, I'm able to say, it's neither one nor the other. That it's going to be contextual, because that's, to it sounds like it's a dodge, Mike, and Mike's laughing in a cynical way. But to me, that's really what you're aiming for. You're aiming to really work with the principles to get to a result that feels right. But the legal background of people, candidates, does matter. I find that people think they've grown out of whatever system they grew up in, but those predispositions really linger. It is cultural. We haven't even talked about civil law versus common law, the civil law, the good faith element in terms of interpretation of contracts, which is more problematic in common law jurisprudence. Absolutely, I think we agree on that you need to really consider and get information about how the particular arbitrator approaches contract interpretation issues. I think that's perfectly legitimate to do. Can we leave it at that? Or
Sure.
the last word.
Me, I would have the last word. Oh, that's unusual. You give council be given the last word. I don't think that's how it's supposed to work. No, I think it's something we should all be alive to, that it is a spectrum, and there's no single approach, and things change over time. So just as individual arbitrators will struggle between certainty, devotion to the text, and avoiding the unfair result that comes, legal systems do too. And part of what I wanted to impart upon you is the choice of law system matters. New York and common law Canada are kind of extremes where different policy choices are made. The New York approach is, let's focus on certainty, let's make the text matter. If there's individual injustice in individual cases, well, maybe people will be smarter the next time they draft their contracts. The Canadian system, reflecting English law, more concerned about individualized justice, about context, about individualized fairness. But even systems can go back and forward. In England, they went very contextualist at one point, and about 10 years ago, the UK Supreme Court started to push back towards the text. And it's something to watch for here. We've gone very contextualist in common law Canada. And I think Friday's decision of the Supreme Court is actually a great example. The Supreme Court overturned a very strong commercial panel of the Ontario Court of Appeal in an extremely contextualist approach. It is a spectrum, it is a pendulum, it may start to swing back, and at minimum, it is something that arbitrators and counsel appearing before arbitrators need to be alive to whenever there's a contractual interpretation issue at stake.
Thank you very much.
Did you break it, Geoff? No, it still works. Well, like I said, I'm delighted to be up here with Lisa Munro, and we really would like to talk to you, or with you, about as many topics as we can cover in the next, 40 minutes or so. We have two that we wanted to maybe focus in on. Lisa, maybe you want to set the stage for our topics, but I was itching to ask a bunch of questions during your presentation, but I bit my tongue, so maybe others felt similarly to ask questions, and I don't see any reason why, if time permits, we could go back to that one as well. So Lisa, your opening thoughts?
Sure. As to format, I think Mike and I are going to present differing views on some of these issues, and we welcome your thoughts. That's why there are two microphones in the middle of the room. So the first topic that we like to raise is one that is on everyone's mind, and that is the use of AI in arbitration, and in particular, the use that should be made of it by arbitrators in drafting awards. Mike, your thoughts?
Well, I'm not a big fan of AI, let me just put that out there to be provocative on a Monday morning. But I did, with the assistance of one of our excellent students over the weekend, have the benefit of reading some materials, and there are quite a few out there. I'll try to find a way to circulate what Aidan, our student, was able to find for us. But for example, on the question of are we ready for AI in decision making, there's a 2023 article that was published by the LCIA by Dr. Christian Aschauer from the well-known Graz University in Austria. He said, not yet. He also said, quote, robots are not very good at nuanced decision making, close quote. The article also refers to the IBM Watson famous failure to diagnose cancer with the same degree of reliability as the computer's human counterparts. The ICER just this past November published an article that was as I understand it, the product of the AI working group within the AAA. And here's a quote that sounds somewhat familiar to what the Austrian professor had to say. While fears and speculations, and just stop there, fears and speculations abound regarding AI's potential to replace human judgment, that would be all the decision makers in the room, our current perspective is not about replacement, but rather enhancement. And we then get into the world that I'm much more familiar and comfortable with, which is that there are opportunities to use artificial intelligence. Joel Richler highlighted for me this morning the word artificial. I said, yeah, but it's intelligence. He said, yeah, but it's artificial. So anyway, document analysis. He said, you know, there could be a Schafler affidavit of 20 pages. You punch it into AI and it distills down to what it really says, which is nothing, or one paragraph. Legal research, if you think about that, but this is where my reluctance comes from. You'll probably have heard of that now infamous BC court decision where AI, unbeknownst to either of the two sets of lawyers, produced two fake cases. And when the respondent lawyers did their homework and looked up the cases before the hearing, they discovered that two of them didn't exist. I think the last I read was that it's before the Law Society now. So there's definitely caution to be exercised. And then the last topic that comes up a lot is document generation. So I think it's a little bit of the summary of Schafler's affidavit, but a little bit more. You know, take 1 million emails and decipher them in a number of minutes, and you have a stream of what all these different people were talking about. So, you know, Lisa, do I want Bill Horton to write the award or some machine? Most of the time, I would lean in favor of Bill Horton.
I think,
Where do I get one of those?
to be clear, I think we're talking about generative AI. Most of us are familiar with other uses of AI, predictive coding, etc. And I don't think any of us has a problem with that. And it's increasingly common that, you know, parties will agree on the search terms that will be used for relevant documents and that sort of thing. When that technology came out, I think a lot of us felt some reluctance about the accuracy of it. And we've moved beyond that. So I think we're now at a stage where generative AI makes a lot of us uncomfortable. I share Mike's views on that, but I think we're there, and there's nothing we can do about it. And if arbitrators are reluctant to use it, we will find that counsel are using it, which means we're going to have to grapple with the newness of this, the potential biases that are inherent in the systems, and where, as Michael says, the technology can help us. But we need to understand it if we're going to use it and if we're going to be able to respond to disputes between parties about, for example, the reliability of evidence that's put before the arbitrator. So it's there, it's coming, and we've just got to accept that. There are a number of evidentiary issues, of course, that arise with its use. And we can talk about that in a moment, but let's just focus on the use of this kind of technology for award drafting. Now, Mike referred to this AAA paper, which I think everybody here should read. There is an AI working group which has compared different kinds of technology for document comparison and for some of the other uses that Mike talked about, compared products and come to conclusions about the benefits and risks associated with that kind of technology. And it's very, very useful. And if anybody wants to know more about that paper, come see me at the break, because it's a real illuminator. And essentially what the AAA working group has said so far is that we're not even going down the road to saying it can never be used for decision making. But what we're saying is right now, it is of great assistance. It can provide efficiencies, and arbitrators can freely use it. So the question really is, where do you draw the line? And a lot of that line depends on understanding the technology. So can it be used to review the record for evidence inconsistencies? the AAA says, that sounds reasonable. That's a great assistance. It can expedite the reasoning, save the parties costs. Can it be used for a chronology when, for example, preparing the procedural history for an award? AAA says lots of use there. What about summaries of evidence, looking at transcripts? AAA says you got the right technology, that's fair game. What about summaries of law? And this means, and this isn't in the AAA AI paper, but what about doing your own research, so to speak, as an arbitrator and getting a summary of the legal principles? Most of us are familiar with the technology now that replaces what articling students used to spend hours upon hours doing, and that is you enter in a search term which tells you the law of whatever, and you get a surprisingly accurate and nuanced analysis of that in the form of narrative, which does in many cases replace what a student or a young associate would do. Now, the cautionary tale that we hear from everybody is what we're calling the human loop. And so you can look at this technology, find it incredibly useful, but you've got to double check it. And so the AAA is saying there are all these other uses that can be made of this kind of technology, but the question that I don't have an answer to is whether you should be using it for this kind of purpose, and that is summarizing the law. And this may be of use to arbitrators who are making a decision based on law that they're unfamiliar with, and perhaps checking to see if the parties have accurately summarized the law, or to give the arbitrator a head start in the middle of an arbitrator to understanding the legal principles, so that when you hear them from counsel, they make sense to you, or they allow you to ask questions about the law. Anybody have views on just that point? I've got a whole bunch of other things to say, but I think this is a kind of a point that's really worthy of some discussion. How far would you go as an arbitrator to use AI for this purpose? And if you've got a comment, please stand up. Arda.
Hi, Arda Barsukov with Bennett Jones in Edmonton. I largely agree with the guidance that was just discussed. As arbitrator, I would certainly rely on AI to assist me with reviewing the record, reviewing the transcripts, identifying consistencies in the evidence. And in particular, I find there's a lot of room to use AI in preparing procedural history. In speaking to more experienced arbitrators than myself, I consistently hear the sentiment that that is the one part of the award that takes an inordinate amount of time to get right and get complete, to make sure that every step of the way is properly documented. And I think there is a lot of efficiency to be realized in relying on AI for procedural history of the award. When it comes to the substance and substantive decision making, I think that should be rightly reserved to the domain of the arbitrator, the human mind, which is what the parties come to an arbitrator for. And that process, relying on AI, will allow an arbitrator to move to that substantive part of their work much quicker and more efficiently.
What are the risks, if any, to using AR, even for the purposes that you're comfortable with?
The hallucinations, of course. The AI can infamously pull information that doesn't exist on the record. And that is why I would always caveat any use of AI with human review. Its use is really to save the resources and to allow the arbitrator to not spend all those hours pulling everything from the record, but do that initial draft. And then when that's done, and a review can be done to make sure that everything actually lines up with the record as the arbitrator recalls it, and referencing documents that may be required to be referenced to double check everything.
I have a question, leaving aside the Oilers bit, but at what point, if at all, do you tell counsel that you intend to use AI, let's just say, hypothetically, in the fashion that you just described?
That's a good question, Michael. In my view, because it doesn't have bearing on the substantive part of the decision, I think that's a prerogative of the arbitrator in how they want to organize their inner workings. If AI was used in any way in the the substantive part of the award, even in informing, say, the evidentiary considerations, then I think at that point it crosses into the realm of where the parties have a right to know.
Because the reason I asked the loaded question probably isn't the right or wrong answer, although I'm always a disclosure type of person. I would have thought that if somebody were to find out later that AI was used, and let's just say they don't agree with your demarcation line of where the substantive starts and the procedural ends. For example, if we're talking about a set-aside application, if the arbitrator used AI and it was undisclosed to the loser, or to both parties, I guess, in that case, would they have some reason to complain later that the procedure that was followed by the tribunal was not in accordance with the parties' agreement and therefore susceptible to potential review?
I think if the agreement is silent on the use of AI, which most agreements probably would be since they were drafted some years ago, the fallback would be the practice of reviewing the AI output by the arbitrator before it actually goes into the award. Even when it comes to procedural matters, my recommendation and my personal preference would be that an arbitrator actually reviews the output of the AI to make sure that it's accurate, that there are no red flags there. And in a set-aside application, the counter-argument would be that the arbitrator had his or her eyes on it, and that is an established practice and a variable practice of the arbitrator to do so.
Anybody else have any views on this? Because please stand and, I mean, I agree with my fundamental policy on this, I think, would be disclosure. It would make, Steve.
Oh,
Sure.
You're up.
I'm up.
And Donnie had his hand up here after Steve.
I disagree with Arthur.
Excellent.
Excellent. Well, I don't know, at my peril perhaps, but this just occurred to me about 10 days ago. It's simple, I hope not overly simplistic. If you would disclose the use of what Joel would call human intelligence in the form of a tribunal secretary writing procedural history or anything, I think one should disclose the use of artificial intelligence on exactly the same basis and for exactly the same reason. If you think you need parties to agree to get another human, you should get agreement, disclosure on the use of a machine, period.
Donnie?
Stephen, you're going to have to relinquish the microphone.
I think the point that Stephen just raised, it's one thing if you're involving a human tribunal secretary, the parties need to consent because here's another person who now knows their confidential information. If you're using a machine, it's not necessarily the same thing. It might depend on exactly how you're using, to your point, Lisa, the generative bit of the AI. If you are using a machine to write you a memo on every time in the last 7 days transcripts that issue X arose, and it summarizes it for you, but it also gives you the references to the transcripts so that you can check it. It's not a black box. And then when you're writing your award, it is still your human thought that goes into how you're dealing with the factual conflict, the evidential conflict, and how you're drawing your conclusions. I'm not sure that there is much ground for the parties to complain. If, on the other hand, you use generative AI to give you a summary of the law on fiduciary duties or good faith, and you're now using that material, that is incredibly dangerous because sometimes that is a black box. It isn't so easy for the machine to give you its trail of breadcrumbs to where the material came from. And then I think you are in much more difficulty. If the AI is helping you to find the source evidence, on the whole it should be fine, but even then it can create problems. What if you're looking for evidence inconsistencies? Witness X has said something. The AI finds an inconsistent email in the record, that counsel didn't put to the witness. Now, you're going to have real difficulty using that out of context. So I think the difficulties, we've not yet seen enough to see exactly how the problems can arise here.
I see another two more hands, but just one thing. On the transcript thing, Donnie, what's wrong with just actually reading the transcripts with your human eyes? And every once in a while, typing, what I've been taught at Denton's, it's taken me 30 years, but I got there now. Control F, and you can find certain things, and I'm being half facetious or cynical, as somebody said earlier this morning, but it just sort of rubs me the wrong way that you're going to tell a machine to tell you where to go in the transcript. And this thing about the email, there may be a rule of law or procedure, depending on where you are, that requires the witness to have been given a chance to be confronted with that particular email. So I hear you, but I'm not entirely convinced yet.
You're a two-finger typist though, Mike.
But
You're a two-finger typist.
I am really good with
So
that.
the efficiencies are clear. The question is whether there are other issues. Edna.
Well, with the BlackBerry, everybody went to two fingers, and I'm a two-finger person too. Edna Sussman from New York. I guess let me start with, I think disclosure is really important. I think the parties have to understand what you're doing. And so, I think that's a non-issue. You've got to do it. But it's the first time I've sent out a first preliminary order, a PO1, and it came back with their edits, and one of their edits was that the arbitrators will not use artificial intelligence. And I think we will be seeing more and more of that. In terms of the substance, I guess I worry about letting them do a summary of the facts because, two arbitrators will see the facts completely differently and it's the same presentation of the same evidence. And so, you don't know where that AI is coming from, whether it's this perspective or that perspective. And I think the human element is the way they've asked us to do it. So I'd be really nervous about it. So I'd be really nervous about relying on AI.
I heard nervous.
I'd be really nervous,
kindred
right?
souls.
I'd be really nervous about trusting AI to have the same perspective that I would have. I have to figure out my own perspective on the evidence. So bottom line, maybe for the procedural section, but not for the facts. The other thing that intrigued me though is, if it's a law you're not familiar with, do we sometimes cheat and look at Wikipedia for some technical thing to see what it says, and then we can listen to the evidence, we rely on the evidence, but we have a little background that we kind of picked up on our own. Maybe it's okay, maybe not, but we sometimes do that for a very technical point. So for a summary of foreign law, when you've got two competing experts saying something completely different, and you can't read the source material because it's not in English, I don't know, I'll have to think about that one.
There's lots of hands up. I think Frank Newbold had his hand up, and Janet has her. We'll try to get to everybody. So Frank?
I just have a question for Steve Dreyer. Let's assume, I have a question for Steve Dreyer. Let's assume that you say, I'm going to use artificial intelligence for this or that. Counsel come back and say, all right, I want to see what you've done. I want to see the artificial intelligence and what it's disclosed to you. Do you say no, because that's part of my deliberation? I don't know what the answer would be.
I'm not sure what the answer would be either, but, and I prefaced what I said earlier by acknowledging it was simple and hopefully not simplistic. My point is simply, if you're going to use it for anything, I think that one should apply the same reasoning as one would apply if one were to use a living, breathing tribunal secretary. If you're going to ask a secretary to do some research, and you're going to disclose that to the parties, they should be the same thing for AI. I don't see why there should be any difference, honestly, right? Because we're calling this intelligence. Mores might shift over time, but to the extent that one wants to use it, I don't know if you can show the work product. Probably not, but any more than one would show the work product from a tribunal secretary. It's simply letting the parties know there is a fourth entity or a second entity involved in any part of the deliberative or drafting process. And again, that's just because where we are now, we tend to think, pardon me, seems to me that one has to disclose that one's using a tribunal secretary to do the most mundane things. And if that's the case, and if you believe that's right, I simply say, so too should one disclose the use of a machine, even for the most mundane things. It's a bit of a dodge, Frank, I admit.
I think Edna wants to maybe rebut, and then Gary had his hand up.
I'm only because I'm with Stephen on this.
That's why I let him speak.
Yeah, I'll second Jared on this. Okay.
Wait a second, did you get permission in this classroom to speak?
In fact, I was holding the mic before, but I'm so polite that I handed it off. But no, just as an arbitral secretary, of course, if you disclose that and you're using AI in that way, you disclose AI. And it would be silly, frankly, not to, because especially in the realm of international arbitration, where I have a little more experience, I can tell if my arbitrator has written what they have written. It's really easy to tell, so why would you ever run the risk? And the problem with AI, I've played with it, I put my writing in it, and it comes up better. I'd love to believe that I wrote that well. No, and arbitrators might be tempted to say, well, of course, that's how I would have written it. But then other people who are more objective would say, I know you didn't. Why would you ever want to run that risk? And as long as you disclose it, you create a protocol, and to the question of what you disclose, you can make that clear. You should even explain which AI platform you're using. It's just a no-brainer to me.
Just like one discloses the identity of a secretary.
There's somebody way in the back, I don't know who it is, I can't see you, but I see Janet waving. There we go.
Matt Patel from Baker McKenzie.
Matt, how are you?
Good, thanks, Mike. I'll bypass the disclosure issue. I think that one's easy to disclose. On team disclose, it won't surprise a lot of people. But implicit in the whole discussion we're having seems to be a bargain, unspoken, that the cost savings, or perhaps more insidiously, the ease that AI affords the arbitrator makes it a worthwhile bargain. And I think that has to be a bargain that our clients, the parties who are paying for the process, who have an interest in the process, have actually agreed to. And I think that we should also be asking ourselves, as people who chose to go to law school, chose to become lawyers, chose to become arbitrators, why did we do it? We didn't do it because it was easy. We did it because it was hard, and it should be. And reading cases beginning to end, reading transcripts beginning to end, understanding that sometimes there's going to be a bit of nuance in there. We've all had cases where there's going to be a word here, a word there, that fundamentally changes the meaning. We should never willingly surrender that to a robot.
I'm going to take over the microphone here. We need a different perspective, I think, from younger generation. So, the perspective I'm going to give is, if lawyers are not going to be replaced by AI, but if you don't start using AI, you certainly will be replaced. And people are speaking in a very general fashion about Gen AI. There's a different category of types of AI that you can be using, including Gen AI. First, if you're putting client information or a party's information out there in ChatGPT, you absolutely have to be disclosing that, because it's not going to be kept private and confidential. It's being fed into the system. But there are already lots of platforms that are in a closed environment. And so we have one at our firm. There are, if you look at the Westlaw, LexisNexis models that they're doing with AI, there can't be AI hallucinations, because it can't go out in the web and find other things or create things. It can only summarize with what you've put in the environment. If you put all the documents in, it can only use those documents. If you give it 10 cases, it can only use those 10 cases. And so a closed environment AI is always going to be safer. And that's something that you could disclose to the parties and you could use. You also have all sorts of Gen AI you're going to be using, and it's a question of whether you need to disclose it when are you using it for math? If you're using it for math, you really need to disclose it. You don't disclose it, you use a calculator to help you with math. If you're using it to spell check and to proofread beyond what we're just using right now, do you need to disclose that? You're already using spell check. Like when you talked about doing Control F 20 years ago, 30 years ago, lawyers weren't using Control F. We read a case front to back, and I don't think they started disclosing to the parties, oh, I use Control F to do my spot key search, keyword search finding. And so I think there is a threshold of where you may need to disclose things and where you may not need to. And there's different levels of fear that don't exist at a certain threshold, and that might when you're using something like ChatGPT, but I think we should keep an open mind to there's a lot of utility in using AI tools, and it does help parties with costs and efficiencies and accuracies.
I'm gonna pick White, Jack. Sorry, you know what? I overlooked Gary now, my AD for the last 10 minutes. Gary, you go first, and then you. Didn't help.
We started to use AI at ADRIC for the last few months. The issue is, when you do transcripts, they become public because it's an auto learning system. So that's one issue that I'd be looking at, but it's helpful because it reduces you could be doing other things and taking notes, you know. The other thing is the basis and where this data is stored is a huge risk because a lot of our RFPs request that we're in Canada. So you have to really look where the data is being stored. Two little things, but it's helping us to be more productive tremendously.
Helen?
I want to take a long view of this issue because arbitration is a alternative decision making, alternative to our judges and court system. We don't want AI to become our judges. We want human judges because of its human elements in the decision making. And I think in this decision, we have to take a long view. There's a floodgate concern here that I see. If you allow AI to, allow you to take an intellectually easy path now to do something in the arbitrary decision making, then 20 years down the road and 30 years down the road, when the AI technologies become more advanced, then we may, as an international society, I'm talking about internationally because domestically it's a different game, but internationally the rule of law could be ultimately taken over by AI. Do we want that, or do we want to keep the human element in the judicial decision making as well as in the alternative decision making, or not? Just like there's something that you can do doesn't mean that you ought to do. There are elevators, doesn't mean that you always take elevators and not for the sake of health, take the stairs. So I think that we need to keep in mind that do we want to give our future 20 years, 30 years, 50 years down the road to AI or to our offspring to maintain our human judgments in the rule of law, domestically and internationally.
I see that John Campion has arrived and put his hand up almost simultaneously. Good morning, John.
Good morning, everybody. What I suggest from this AI piece is, number one, use it and use it often as much as you can. Because if you don't, you're just going to get left behind. As to whether 20 years hence we're going to be, the AI will replace us or not, it seems unlikely. People will always want a human intervention. But where I have used it is exotic questions from time to time and evidence, like simple fact evidence that came up. I recognized it. I jumped onto ChatGPT, gave me the 4 points. I knew the 4 points more or less. And so I could confirm in my head that they worked and went on with it and said to everybody, look, this is a similar fact evidence. You can argue it, and if you want to do it tomorrow morning, again, and they did. So my view is that AI is upon us. There's no doubt about it. We can't stop it. We're just going to simply be left behind unless we use it to our own advantage. And as to whether we get replaced or not, well, the courts are going to be in the same position. So I just say go with it. We are where we are now, authoritative in our decisions, but use ChatGPT 4.0 and all the other pieces. If you don't, you simply will be left behind. And the more you use it, the more you realize it's really just a statistically based, analytical, without judgment tool right now, and it may never be anything more.
Well, John, you just said it's without judgment, and I wonder, everybody talks about the biases that are inherent in these systems, and it depends on the data, of course, that goes in, and if you are using them, of course, you should understand them, but how do you understand the biases? How do you, if there's transcript summaries, maybe there's less danger of this of the bias than in other circumstances, but I understand Edna's concern about how facts might be articulated. How do we understand what biases are inherent in the system? And it seems that it's necessary to understand those before we can make use of and rely upon. Gentlemen, no. Who's over here? Oh, Scott.
Scott Fairley, Thank you. Everybody's been talking about the extent of true confessions of the arbitrator as to where you're getting your stuff. And I'd just like to turn the telescope the other way around. Is an arbitral panel or an individual arbitrator entitled to compel or at least ask politely for the same level of disclosure from counsel? The comment was made earlier that whatever we do as arbitrators, you don't know where the other side is coming from. And if we're talking about disclosure for technologies like this, which still have uncertainties in them, are we entitled to obtain the same level of disclosure from the other side, from our counsel, in terms of the information that we're receiving and making decisions on, as opposed to just spilling the beans to them? It seems to me it should be a two-way street. I would like comment on that.
The courts and the law societies across Canada are actually grappling with that right now. For example, the federal court is requiring a declaration in, for example, the factum, if AI has been used to generate any information in the factum. Some of the other courts are just urging caution and studying the issue. The law societies, for the most part, are considering this issue as part of the rules of professional conduct which require counsel to understand and be competent in whatever they're using. So this is on the radar, and we're seeing protocols, directions to the profession, studies that are as recent as the end of 2023, early 2024. It's on the radar, but as I say, the courts and the law societies are dealing with these issues in slightly different ways, and I think we'll see eventually some consistency, but it's a good question. And I think that my view is that if there's disclosure by the arbitrator, there should also be disclosure by counsel. Stephen, you want to rebut?
So just a second.
We can't have two people in charge.
The term two-way street, Scott, I know, I'm sorry. The two-way street though, you said it. I mean, we were looking at, what might be interesting topics for this morning. This came up and it was like, yeah, we'll talk about it for 5 minutes and nobody will be interested in it. But we talked about disclosure and two-way street. So it's kind of interesting because that's come up a lot. All of the parties, the tribunal have to be part of this. And as you said, Lisa, the law societies, the judiciaries are all waking up to it. So John Campion, you may actually have been correct in saying it is upon us. So that's just my view. But there were other hands, right, that I interrupted, as I tend to do.
I just wanted to...
I interrupted you, Frank, but Stephen I interrupted first, so I did 2 in 5 seconds.
I don't want to...
Sorry.
I'll see my interrupted comment to Frank.
There you go.
Well, all I wanted to say was that if counsel are starting to have to disclose things, it's one thing to say to a court, I've used artificial intelligence. It's another thing to say, here's what I've done, here's what I found out, because that's all privileged. And how far do you go to break the privilege that the counsel have for their work product?
I was just thinking, I mean, you may be right, but is it privileged if let's say it's not a closed system. I guess it's like the solicitor's brief. Is that what you're sort of thinking? Yeah, Lisa?
I don't know, parties may agree on what technology they're going to use in the same way that they used to, or they still agree on the kind of platform that will be used for document sharing. I'm not sure. If, for example, the parties agree that they're going to use a certain platform for transcript summaries, that's a that will generate probably solicitor-client privilege information, but when it gets actually used in submissions that are made to the arbitrator, I don't think that that is solicitor-client communication, but it may be of interest to all the parties present that what has been used to generate that work product has been generated by AI. That's how I kind of see the issue. But there's another issue that we haven't yet talked about, and that is evidence and the reliability of evidence, and how the arbitrator will assess it and how the parties will put it forward. So you can see in an advertisement, for example, that people's iPhones will allow visual evidence to be altered. I can make you can put a puff jacket on the Pope. And so when parties are introducing evidence and there's a dispute about whether it's reliable, authentic, etc., how do arbitrators assess that? We know that the threshold for admissibility is fairly low. If the parties both agree that a certain kind of evidence has been generated in this way, it seems easy. But what if the parties disagree? How does the arbitrator assess the authenticity, the reliability, the admissibility of that evidence? I don't know the answer to that, and it seems that this is another example of how arbitrators will have to understand the technology, but it may be that we're going to be getting expert evidence in a way that we've never seen before.
Is there another hand back there?
Yes, Patrick Goudreau. So I think we just have to realize that we are in a transition period. So maybe in 10 years, that would seem silly to have this discussion. But now we're in transition. So I think we should play safe. What does it mean? There's an issue of security. So we want to make sure that the data, the information stays secure and confidential. So maybe we should agree on certain rules, so that's one thing. Second, if we don't disagree, it means that it's allowed. So AI, without saying that you cannot use it, it could be used because it's not illegal. So, but play safe. Just agree on the term in your arbitration, because what you want to avoid is to have an argument later on that it was not divulged, it was not agreed. And so why putting yourself or the arbitrator or the party exposed to that argument? So you want to play safe. And also use the basic that you need to divulge all the information you use and you enter in AI, same as when you cite court decision, it has to be on, using public reference. And so you allow yourself to use the tools and you prevent hallucination or later debate. And I think that the idea is just play safe and let's see in 5 years, 10 years, but I think that would be my recommendation.
I had a thought, just Patrick, it follows a little bit on this. So last November, we were in Halifax at the ADRIC conference, and I think Emily and one other colleague, they did a little demo. They went up on the stage. Chloe, was it you? I can't remember. Anyway, they went up on the stage and they punched in a bunch of words into ChatGPT 3 or 4, and it said, please produce procedural order number 1. And this document was created on a big screen in front of us, and we were watching. And I saw Bill Horton was taking notes because I think you said there were 1 or 2 things in there that interested you, that were new. And so I was kind of curious, how many people in this room have seen reference to AI protocol, rules, use, limitations, whatever, in PO number 1? I see no hands. I see Edna's hand up, sort of quizzically. What kind of a question is that, Mike? Edna.
I just want to say, picking up on Lisa's point about fake evidence, you all have to watch this. There is a video of, it's Reid Hoffman, the guy who founded LinkedIn. So he has his virtual twin who has read everything that he has ever written or spoken. And so you have the real Reid on one side of the screen, and you have the virtual Reid on the other side of the screen. And he's asking questions in the virtual one. And it's astonishing. You really all have to watch this. He will ask a really complex question, like, you know, from the perspective of 4 different people and different trains of thought, how would you explain this? And, you know, like that, the virtual guy comes up with excellent answers from all 4 perspectives. It's just astonishing. So in terms of what can be created, in terms of false evidence, and it looks really real. I mean, this guy looks more real than the real guy. You know, you've seen all those studies where you can't differentiate between the real picture and the not real picture. So I think we're going to be seeing a lot of it, and it will be interesting to see what kind of expert evidence comes in to tell us what is and what isn't real. It's like taking fake evidence to the nth degree, and I think that's what we're going to be seeing. You have to watch this. Read half of it. The video is amazing.
There are 2 material developments, actually 3. Janet has to do with one of them, I know, because she just rose and basically rose to say your time is up. While she did that, Stephen was putting his hand up. Stephen, I don't know if that changed your mind at all, but I think we've... Okay, go ahead then.
Maybe you should, but look, far be it from me to claim the advantage of Alexandra's perspective, but let's be frank, right? What was that old movie with the catchphrase, they're here? AI is here, right? It's not going anywhere. It's got some serious risks, but again, let's be candid, right? People, yes, gasp, even lawyers, have been presenting false evidence to courts and tribunals for hundreds of years, right? And part of the process is intended to try and winkle that out. Yes, it's more difficult, presumably, with AI, at least with current tools. But, you know, Photoshop doesn't have to be disclosed. Photoshop isn't, forbidden. It should be, perhaps. But, you know, the job of the tribunal, the job of the adversarial system, or even the inquisitorial system, is to try to winkle out the false from the real evidence and then to make a decision. So, I think we should just calm down. Right? Step back, all right? Word processing was new at some point, right? Photoshop was new at some point. AI is a challenge, but it ain't going anywhere. And if it's not embraced, we will be run over. And you don't even have to take it from me, just it'll happen, all right? Without us necessarily turning into the Terminator world where the machines are running us. I mean, of course that's a human fear. But there you go. Let's just be realistic.
One last comment from you, sir.
Hi. So, I'm not a lawyer nor an arbitrator. I'm an engineer. Right now I'm just kind of a DAC consultant. In terms of embracing it, you're right. We should embrace it because it's going to stay, it's going to grow. We haven't even seen what it can do yet. But to your point, you have to understand it. We're talking about machine learning. So, very simple, garbage in, garbage out. Give it context and test it for you to understand it, for you to understand what it can do. And giving it context probably means grab an all case files that you have, introduce it, and see the results and compare it to the real thing. Because if not, if you try for new cases and new information, sure, you're gonna have some written statement that it sounds good, but you have to test it and be sure, because at the end, you are the ones responsible for it, not ChatGPT. So the closed environment part that she mentioned is really good, and you should work in a closed environment and do not expect false testimony. The writing part that you mentioned, you could also say, write like me, if it writes too well.
Oh yes, I tried, it's still better.
But anyways, that was my message. Understanding it is, I think, the way to go. And to understand it, just give it context. That's it.
Thank you. We are out of time. Donnie's looking very anxious. It will be the first panel to throw off the day. So I think we're going to a coffee break.
Yes, and before we do, a round of applause.